Have you ever heard this trope, this myth, this talking point that the Constitution is not a suicide pact? Usually as an excuse to take away one of your rights. It's like, oh, well, yes, we have the right to keep and bear arms, but the Constitution isn't a suicide pact. We have free speech, but it's not a suicide pact, so we need to censor. Yeah. And this is actually from a 1949 Supreme Court dissent, not even a decision, not even anything that's precedent, and yet we keep hearing it over and over again. So let's get into this from Jacob Sullum. Yeah, so this is about the case of Arthur Terminiello, where you had 1,000 or so protesters, which was organized by evangelist Gerald L.K. Smith, a flagrantly anti-Semitic populist and spectacularly unsuccessful presidential candidate who founded the America First Party. Angry protesters tore people's clothing and hurled vegetables, rocks, bottles, and stench bombs, breaking more than 24 windows and injuring 3 officers. There were 19 arrests, though most of the charges were later dismissed. Terminiello, a suspended Catholic priest from Alabama who was advertised as the Father Coughlin of the South, was charged with breach of the peace. You always gotta love that one. That's right up there with disorderly conduct, creating a nuisance, all those other, vague things they can get you on. A jury convicted him even though he didn't participate in the riot. All he did was speech. So Terminiello argued that he was being punished for constitutionally protected speech, challenged it in the 1st District Appellate Court and the Illinois Supreme Court. They all rejected him, so he took it up to the Supreme Court. And in May 1949, they ruled that the ordinance under which he had been convicted, as construed by the trial court, was inconsistent with the First Amendment. The municipal court judge had said that misbehavior may constitute a breach of the peace if it stirs the public to anger, invites dispute, brings about a condition of unrest, or creates a disturbance, or if it molests the inhabitants in the enjoyment of peace and quiet by arousing them. And SCOTUS said that just wasn't compatible with freedom of speech. Alright, so William O. Douglas was writing for the majority, and he said, "A function of free speech under our system of government is to invite dispute. It may indeed best serve its high purpose when it induces a condition of unrest, creates dissatisfaction with conditions as they are, or even stirs people to anger. Speech is often provocative and challenging. It may strike at prejudices and preconceptions and have profound unsettling effects as it presses for acceptance of an idea. That is why freedom of speech, though not absolute, is nevertheless protected against censorship or punishment unless shown likely to produce a clear and present danger of a serious substantive evil that rises far above public inconvenience, annoyance, or unrest. There is no room under our Constitution for a more restrictive view." And this is something you may have heard about called the Heckler's Veto. So when student protesters disrupt speeches by people whose views they abhor, or when such events are canceled by university administrators worried about the unrest they might provoke. So it's not the speaker that's causing the problem. It's the people who don't like the speaker and are going to be protesting and causing unrest, and they say, well, you're just too dangerous a guy to have here, so we're not going to host you. Which is, in effect, giving the mob what they want. That's the heckler's veto. The hecklers, the people who are causing the problem, can veto the speech of the person. And win. Douglas's insistence that speech must be tolerated, even if it results in bitter disagreement, is likewise salient when issues such as police brutality, immigration, and Israel's war with Hamas provoke protests and counter-protests in the streets or on campuses. But Terminiello is also remembered for a dissent that took a less accommodating view of free speech. Here we're getting to the Suicide Pact. That was from Justice Robert H. Jackson, who had previously served as Solicitor General, Attorney General, and Chief U.S. Prosecutor of the Nuremberg trials. He said Douglas and the 4 colleagues who joined his opinion were out of their minds. Like many Americans today, Jackson perceived a country on the precipice of chaos, with right-wing and left-wing extremists staging deliberately provocative demonstrations aimed at overturning democracy. See, nothing is new. There is nothing new under the sun. History may not repeat, but it does rhyme. Drawing an analogy to the violent clashes that set the stage for Adolf Hitler's ascendance, of course, Adolf Hitler, gotta bring him into it somehow, he argued that the majority's understanding of the First Amendment was a potentially lethal threat to democracy, freedom, and coexistence. So here's what the nutbar said. This court has gone far toward accepting the doctrine that civil liberty means the removal of all restraints from these crowds, and that all local attempts to maintain order are impairments of the liberty of the citizen. The choice is not between order and liberty. It is between liberty with order and anarchy without either. And anarchy's bad, of course. There is danger that, if the court does not temper its doctrinaire logic with a little practical wisdom, always the practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact. Yeah, we just need common sense restrictions, you see, practical wisdom, that's what we need. In the decades since, that formulation has taken on a life of its own, cited as a justification for expanding government power and restricting individual freedom in situations far afield from the original case. The continuing influence of the suicide pact meme in legal and political debates is remarkable for 2 reasons. First, Jackson was expressing a view that the Supreme Court has emphatically and repeatedly rejected. Second, his concluding admonition was a rhetorical flourish, not a logical argument. Confusing the two invites shortcuts that sacrifice liberty on the altar of order. As it always is. As it always has been from the start. Okay, I'm going to skip a lot of this. These are just details of the case. Yeah, basically Terminiello was saying a lot of anti-Semitic stuff and just riling people up against Jews. Not a very nice guy. Alright, let's get down to the Illinois Supreme Court. Terminiello's epithets directed to certain members of the audience, i.e. the slimy scum that got in by mistake, were derisive fighting words. We've talked a bit about the fighting words so-called exception. We'll talk about it a little more. Likely to cause a breach of the peace by the addressee, words whose publication constitutes a breach of the peace by the speaker. When an audience member called Terminiello a goddamn liar, the court added that represented an actual breach of the peace within the auditorium. Notice that it was the audience members who breached the peace. Lippman's report that she was very wrought up and felt like committing violence was further evidence of Terminiello's guilt. So he's responsible because someone else wanted to commit violence. As for the majority of the audience, Terminiello's provocative and inflammatory utterances instilled in them the fear of revolution, domination, and murder. Murder most foul. By what he described as the criminal Jewish element in America, and more particularly by the mob outside the auditorium. And so they concluded that Terminiello aroused his audience to a feverish feeling of anger and hatred. It rejected the false impression that great constitutional questions are involved and sacred constitutional rights are jeopardized. Chicago's ordinance is a common one and does not violate constitutional rights, the court said. Freedom of speech is not license. The Constitution does not absolve one for punishment for the unlawful nature and consequences of his speech. All right, let's talk a little more about this fighting words claim. Let's start down here at Chaplinsky v. New Hampshire. This is something that Jackson referenced. The Supreme Court had recognized a First Amendment exception for fighting words. those which, by their very utterance, inflict injury or tend to cite an immediate breach of the peace. That unanimous decision, joined by Douglas and 3 of the 4 justices who agreed with him in Terminiello, involved a Jehovah's Witness, Walter Czaplinski, who attracted a hostile crowd while passing out literature and condemning the racket of organized religion on a sidewalk in Rochester, New Hampshire. Sounds like my kind of guy. When a heckler tried to punch Czaplinski, the town marshal, James Bowering Jr., warned the preacher that he was asking for trouble, then left the scene. After several men assaulted Czaplinski, they assaulted him, remember. A traffic officer, rather than trying to disperse the crowd, took him into custody and began escorting him to the police station. On the way, as the officer and several members of the crowd insulted Czaplinski and his religion, Czaplinski again encountered Bowering, who reiterated his earlier warning and, according to Czaplinski, cursed at him. In response, Czaplinski condemned Bowering as a damned racketeer and a damned fascist. Because everyone's a fascist, you know. Czaplinski was convicted of violating a New Hampshire statute that made it illegal to address another person in public with any offensive, derisive, or annoying word. Boy, does that sound familiar. Look at what's going on in the UK today. Or call him by any offensive or derisive name. The trial judge read that law as applying only to words tending to cause a breach of the peace. So construed, the Supreme Court said, the law was consistent with the First Amendment. And of course, Terminiello went against that, so... In hindsight, Terminiello may have been the beginning of the end for the fighting words doctrine, which the Supreme Court declined to apply in that case and never again invoked to uphold a prosecution. But as Belmont University law professor David Hudson noted, the concept remains part of First Amendment law and has been used by many lower courts to uphold convictions for breach of the peace or disorderly conduct. By contrast, the Supreme Court has explicitly repudiated the clear and present danger test, alluded to in Terminiello. A unanimous court applied that test in the 1919 case, Shenck v. United States. We talked about this. This is the one where you get that fire in a crowded theater trope that we've debunked so many times on this channel. That upheld the Espionage Act of people who were protesting the draft. They were distributing flyers, say, hey, we don't think the draft should be a thing. We think that's bad. And they arrested and convicted them. So they ditched that standard half a century later in Brandenburg v. Ohio, which we've also talked about quite extensively. That was Clarence Brandenburg's conviction for violating an Ohio statute that made it illegal to advocate crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform. Under Brandenburg, even advocacy of illegal conduct is constitutionally protected unless it is both directed at inciting imminent lawless action and likely to do so. Those two parts of it. Jackson cited the violent protests that accompanied Terminiello's speech as a reason to punish him, but the riot was already underway before he opened his mouth. Boy, does that sound familiar too. Jan 6, anyone? Jackson himself made that point during oral arguments in the case. The disorder started before the speech was made. Does a man have to cancel a speech because he anticipates antagonism? And he asked Chicago's lawyer, L. Lewis Carton, was there any greater disorder after the speech than before? And Carton replied, no. So how is he the cause of it? How's he to blame for it? The rioters, in other words, were reacting to a speech that had not happened yet, a speech they probably could not hear even after Terminiello got started. Yet, if there had been no riot, it seems clear Terminiello would not have been arrested for delivering hateful remarks inside a private auditorium to people who voluntarily came to hear him. The anarchy that Jackson feared does not flow inexorably from speech that stirs the public to anger, invites dispute, brings about a condition of unrest, or creates a disturbance. It happens only when people respond to words with violence. People who act on that impulse should be punished. They should not be rewarded by restrictions on the speech that offends them. All right, I'm going to skip a bit more of this. They talk about some more cases that have happened since then, including some recent ones post 9/11. Yeah, of course, Jackson's warning has also figured in the gun control debate. The Constitution's a sacred document, said Lindsey Graham, but it is not a suicide pact. And there he was talking about banning gun possession by people on the no-fly list. You remember that no-fly list? Where you could just get on it and not even be told about it without so much as a court hearing? And even if you did find out that you were on it, there was no real way of getting off of it. Yeah, it was just like a secret list. This is not hard for me. Due process is important, but at the end of the day, we are at war. No, you weren't. You never declared war. Congress never declared war after 9/11. Congress hasn't declared war since World War II. 3 years later, Graham used the same thing to defend red flag laws. The Second Amendment's important to me, he told the state, but it's not a suicide pact. All right, we've also got the Uvalde shooting. This was from Mary Gay Scanlon of Pennsylvania. The Second Amendment is not unlimited, and it is not a suicide pact. Gavin Newsom said the same thing. The Second Amendment is becoming a suicide pact. The U.S. Court of Appeals for the D.C. Circuit quoted Jackson's Terminiello dissent while rejecting a challenge to the Trump administration's unilateral ban on bump stocks. And special counsel David Weiss even said in his case against Hunter Biden, the Second Amendment is not a suicide pact. And going back to 1996 in CNN, Bruce Fein defended indefinite civil commitment of sex offenders after they have completed their sentences. Just keep them in jail anyway. I think Justice Robert Jackson had the answer. He said, the Bill of Rights is not a suicide pact. Oh, and of course, all over the place in COVID-19, the Ninth Circuit invoked the dissent when it rejected a challenge to California's ban on in-person religious services in 2020. Remember that, when they shut down all the churches? So did two Rutgers University policy fellows when they defended New Jersey's similar restrictions, arguing that the government can restrict behavior to serve the common good. That's another thing we have, the common good, the greater good. And people always say, oh, the needs of the many outweigh the needs of the few, or the one. That profound statement from Star Trek II, ignoring the fact that Star Trek III showed how that was wrong and completely repudiated it. Because all of that happened because that they felt that the good of the one sometimes outweighed the good of the many. And when you're talking about your individual rights, that is absolutely the case. And in 2021, a CNN opinion piece urging the mandatory forced COVID-19 vaccinations, the Constitution is not a suicide pact guaranteeing a right to harm others. Oh, lots of other examples. Just example after example. You can read over it. I'm not going to go over all of these. Let's go down to these purported exercises in suicide prevention are naked attempts to justify censorship by absurdly inflating a supposed danger and appealing to the authority of a renowned jurist. And even when speech restrictions might be justified, as with the gag order against Trump, oh my God, Solom, you were doing so well. No, there is no justification for the gag order against Trump or any criminal defendant. That was 100% a Heckler's veto. Read Mershon and read, what was the other guy's name? The nipple judge, Engeron. And the Jan 6 case, what Tanya Chutkan said. It was all the Heckler's veto. That's all it was, because if Trump said something, oh, that might affect democracy because people might get riled up and riot or whatever. No. You cannot use someone else's actions to restrict that person's speech. And especially in a court of law. A defendant has that and must have that. Because the news is reporting their case and they're getting all this information and they were getting it from the prosecution. They were leaking it. They were leaking it to the New York Times and the Washington Post. Trials can cause a lot of reputational harm. And the only real way you have of defending against that is not in court, but in the court of public opinion. And when they talk about all these gag orders about the First Amendment in court cases, it's been cases where it's been like the press, and that affects the defendant's Sixth Amendment right to a fair trial and to an impartial jury if they're tainting the jury pool. And that's the argument. You have two constitutional rights, the Sixth Amendment and the First Amendment, clashing against each other. Well, if you say the press can't report on it, they can still report on it when the trial's over. There's not that much harm. What's the harm to the defendant if he cannot get a fair trial? That's a harm for life. And so when those two amendments clash, the defendant's Sixth Amendment right outweighs the press's First Amendment right. Well, in this case, the person wanting the First Amendment right and the person with the Sixth Amendment right were the same person. So how does that clash? If they're both your rights, then you decide how you move between one and the other and how you prioritize one or the other. There is no justification whatsoever for these gag orders, and if they're allowed to stand, I'll say this again, they can do that to any one of us. So shame on you, Solomon, you got that one wrong. A persuasive defense requires reasoned argument as opposed to intimations of imminent doom. Yeah, and that is why the Trump gag orders weren't justified for the exact same reason. Inveighing against suicide pacts adds nothing to the logical or legal case for any particular policy. Alright, I don't think there's much more. No, there isn't. Okay. Usually, however, people who say the Constitution is not a suicide pact view that statement as a trump card. This policy might be unconstitutional, they implicitly concede, because otherwise you wouldn't need an excuse. You would just say, no, it's not a... So you're trying to make an exception, and you need an excuse. So it's unconstitutional, but we should pursue it anyway, because the stakes are too high to follow doctrinaire logic rather than practical wisdom. That way of thinking is tantamount to saying that civil liberties should be respected only when it's convenient, which will be suicide of a different sort. Yeah, other than that one bit, good article, and really important to understand. This is why the First Amendment needs to be protected. And Donald Trump says he's going to do that in his upcoming, well, not upcoming, as of yesterday as I record this, administration. We'll see how much better he does with free speech. He says he's reformed on that. He says he's going to support it. Hopefully he will, but time will tell. Thank you so very much for watching. Comments for the Comment God, shares for the Share Throne. Please hit like, subscribe, and the bell, and go to donate.bogosity.tv to keep me doing what I do. Keep these videos coming with individual donations or regular subscriptions that let you get these videos early and ad-free. Thank you so very much for watching. Until next time, stay strong and be free. First, Jackson was expressing a view that the Supreme Court has... Jackson was expressing a view that the Supreme Court has emphatically... Jackson was expressing a view that the... Lippman's report that she was very wrought up and felt like committing violence was further evidence of Terminiello's... Terminiello, and never again invoked to uphold and has been used by many lower courts to uphold convictions. A traffic officer, rather than trying to disperse the crowd, took him into custody. Chaplinsky again encountered Bowering, who reiterated his earlier warning, and, according to Chaplinsky again encountered Bowering, who when a heckler tried to punch in hindsight, Terminiello may have been the beginning. These bloopers are going to be longer than the videos, aren't they?